and to really celebrate the start of a long journey, because the wheels of justice oftentimes do turn slowly, and there are a lot of ups and downs along the way, but we are confident that in the end, justice is going to prevail, and this building will remain a part of Nashville. Amen. If anyone has any questions, be happy. I'm going to be here the rest of the day as well, so I'd be happy to answer any questions that you might have. Yep.
How long before you hear something from the court about the motions you filed today, please?
Well, we filed the initial paperwork, and this will be the start of a process. What will happen is the court will have to have what's known as a right to possession hearing. Fortunately for Tennessee citizens, and the legislature established this in law in 2006, the burden is on the government to establish why they're doing this take. And that's different than several other states where the burden's on the property owner to make the case. So that's going to put the burden on them. So we're going to have a lot of back and forth. We want to know the basis for them claiming that this is a blighted area or that eminent domain is appropriate. We'll have a lot of exchanges of paperwork and documents, probably some fights over those documents, and then sometime in the next several months we'll have the right to possession hearing, and hopefully that's as far as it will go. We'll never get to the question of just compensation, because Joy doesn't want compensation. She just wants to hold on to her property.
Exactly.
So,
Scott, what about this case attracted your attention? Why throw your might behind it?
Yes. Well, as I mentioned, the Institute for Justice is a nonprofit public interest law firm. We're able to represent people without charging the folks that we represent. So that's a great benefit, but that also means that we can only take on a small number of cases. Three things that attracted us to it. One is it was an opportunity to really put some teeth into Tennessee's eminent domain law. We've had this law that was passed back in 2006. It needs to be enforced, and this is a case that will allow us the opportunity to make sure that the rights of Tennessee citizens are protected under this new law. It was also an outrageous abuse of power. Here you have a developer who is not even from Nashville or is not even connected to music in any way, trying to throw out somebody when they even admit that they don't have to do it. So that just seems to be incredible, that they've admitted that they don't need the property. They could make their own accommodations. And Joy isn't opposed to them building on land that they already own. That's totally fine. So the fact that they wanted to do that even when they didn't need it was outrageous. And lastly, we had somebody who was in it for the right reasons. We represent people who are fighting this because they truly don't want to give up their property. And that was exemplified in every article, every quote that I ever read from Joy Ford, that this was not about the money for her. This is about a fight for what is rightfully her and her family's, and it was a fight for principles and for the Constitution. So it was those three elements that made it so that we decided to take on this case.
Joy obviously feels very strongly that this is not just about her, it's about protecting everyone in this room and then beyond. Do you see this as a small case that could apply to a large group of people as well?
Absolutely. I mean, one of the reasons why we exist is to set precedents, to take on cases that it's not just about somebody in Nashville or up in New London, Connecticut, or Canton, Mississippi, all the other places where we represented folks, but they're really representative of larger battles. And even though the world has changed after the backlash against the Kelo decision, eminent domain is still being abused, and governments and private developers have not gotten the message, and they're still willing to team up and take land that is not rightfully theirs. So we really do see this as a test case, as a very important case, not only for folks in Tennessee, but really for folks throughout the country as well.
Can you see this case ending up in the Supreme Court again?
Well, certainly. We've raised claims under both the state constitution and also the federal constitution as well. I could certainly see it if the NDHA decides to keep fighting this rather than simply doing the right thing and leaving Joy alone. it could end up before the Tennessee Supreme Court. You know, what happened in the wake of Kelo is that a lot of state Supreme Courts had not looked at this for decades, had not looked at eminent domain law for decades. And since Kelo, 2 state Supreme Courts have rejected Kelo, another 4 have said that they're likely to do so. The Tennessee Supreme Court has not looked at this issue since the 1950s, so over 5 decades since that time. So this is a test case and a cutting edge case.
How can a lower court reject what a Supreme Court?
Well, the thing is, there really hasn't been any law on this. I mean, we're interpreting a law. This is a blank slate here. The legislature changed the law in 2006. There haven't really been any decisions interpreting that law. And then as the case makes its way up, the court has the opportunity to both interpret that law and then look at the proper understanding of the Tennessee Constitution as well.
This could kind of overturn Kelo.
Well, it could reject Kelo in Tennessee. That's certainly the case, because remember, the Kelo case only applied to the U.S. Constitution. Tennessee, thankfully, has its own public use provision, and the state courts can enforce that provision as they see fit. So, yeah.
What are the point of laws that you're going to be arguing?
Well, several of them. We raised, I'll give you a copy of the answer. We raised 5 objections to this. One is the fact that the MDHA no longer has statutory authority for this. They're relying on a blight law that is no longer in effect. We're also going to challenge the blight designation itself. From our review of this, the property surveys were done in a very slipshod way, a very sloppy fashion, and we don't think that they would be held up even under the old blight standard as well. To give you just one example, to have a blighted area, Tennessee law requires that an area be dilapidated, to have extreme deterioration or decay. And even the MDHA admitted in the property surveys that they did back in 1999 that not one of the properties here was dilapidated. Not a single one. Now, some of them they said were had major deterioration, but not one was dilapidated, and there's problems with that survey. That will be another basis for it. The other 2 will be there's no public use under the Tennessee Constitution or under the U.S. Constitution, and finally we're saying that the taking is not necessary as well, especially given the fact that the developer itself has admitted that they don't need the property. So those are the 5 objections will be raised.
Well, you said this is the first case in Tennessee. What's your good?
Yes, this is the first case on eminent domain with Lydia. We have a case up the road in Clarksville where the government there is trying to do a redevelopment plan, and the citizens have risen up against it and have voiced their outrage about it. And what's happened there is that one of the city councilors, who also happens to be a developer, sued this citizens group for defamation, for $500,000 for daring to speak their voice, saying that the government's being controlled by developers, engaging in classic political speech. So we're representing that citizen group to make sure that not only is eminent domain not used for private development, but that the people have the right to speak out against it, as all of you are doing here, without fear of being sued.
So what you're saying then is that's a First Amendment case, not a Fifth Amendment case?
Yeah, that's right.
So you consider this your first Fifth Amendment?
This is our first Fifth Amendment or public use, Article 1, Section 21 of the Tennessee Constitution as well. Yeah, that's a First Amendment case and not a public use case. So, well, listen, why don't we adjourn here, head out for some food and beverages, and I'll be around if you have any further questions and